Thank you for joining us today or for this workshop on ethical and legal guidelines in data sharing. My name is Hina and I am a senior research data officer. Um, I work within the research data management team based at University of Essex. Before we begin, just a quick activity, just to let you know that I will be using Mentimeter throughout the workshop. So I would suggest you to keep it open on your phone. You can open it on your phone or any other device if you like. You can scan this QR code to access the Mentimeter from the camera of your mobile phone, or you can just go to menti.com and use this code. So there is just one quick question there while it will give us time so that some more people can join while uh, we do this. So the QR code is in front of your screens and the numerical code is well. I'll give you some time to join. So before I begin, just to plan some content or some events in future, if we are missing one, I just wanted to check with you, is there any specific aspect of ethics and legal compliance that you are particularly interested in and you have joined today? So this will help me amend the current content in this workshop or maybe planning some new workshops. So data sharing agreement in a research, funder requirements, options for restricted data sharing, qualitative data sharing, that's great. Long-term storage of sensitive data, really diverse topics. Handling personal data, anonymization and sharing. My colleague Maureen, I think she runs a workshop on anonymization. I'm not sure whether she has already done it or there is one coming up. You can always check this on our events page or on our YouTube channel. There will be a recording of the anonymization workshop, and she is an qualitative data expert as well. So AI and ethics, yes, that's the new one, new trend. Qualitative data sharing, collection of personal data overseas, Creative Commons licenses. So AI, long-term sharing, qualitative data, AI ethics. Yeah, these are metadata quality. That's great. Data storage. Yeah, when doing qualitative interviews, how is the best way of ensuring it is completely anonymous? I think we do have an anonymization tool, and if you check the workshop recording on anonymization or on our YouTube channel, you might uh, find this information there. So open data sharing, level of detail needed about data use and sharing in participant information sheet. All right, thank you. Lots and lots of new ideas. Thank you very much. We will certainly plan uh, some more, I think, topics, new topics, or I will try to amend or add some new content in today's workshop as well, based on your responses. Thank you very much. It's really helpful. So the overall aim of this session is to show you the key considerations in primary and secondary data sharing. First section focuses on the key principles of ethical research set out by ESRC, which is then followed by the next section on legal frameworks that govern research data. And I'll also be covering the role of consent briefly here when it comes to data sharing. It's brief because the time won't allow me to go into detail, but I will be running a workshop on consent issues I think it's next Tuesday at 10. You can register for that as well, where I'll show you the template that we advise to use and the consent form and participant information sheet wording and what to avoid if you plan to share data. So that would be useful if you are interested. So finally, I will talk you through to the key considerations in secondary data use, and I will answer your questions in the end if we have enough time. Otherwise, I will answer your questions on the Padlet and you can just see the responses. As I said, here is the QR code for the Padlet. You can keep on adding questions. I will keep the Padlet open for 48 hours and I'll keep on answering your questions if there are any um, during those 42 hours. So, sorry. Um, as you may be aware that research data is of two types, primary data and secondary data. Um, Primary data is the data that is collected by a researcher directly from the original source through experiments or surveys or interviews, observation, focus groups, and so on, while secondary data is an existing data gathered from studies, surveys, or experiments that have been conducted by other people or for other research, such as existing sets at repositories, archives, essays, reviews, or any information on social media. Yeah, so this could be classed as secondary data. So in the first section, which is related to primary data, I'll be discussing the key principles of research ethics, and I will also talk you through some of the ethical considerations and best practices in data sharing, including research ethics self-assessment tool that has been advised by UK Statistics Authority. Yeah, so yeah, just another brief break. If you could please go to menti.com for a quick question. That would be helpful. So this is the code and this is the QR code. Sorry. So what do you think are your ethical obligations as a researcher when sharing your data for future use? Please keep in mind that I'm asking about ethical obligation in the context of data sharing. If you can just share your thoughts. Correct permissions. Yes, that's right. Absolutely. Consent, informing the participant, protecting personal information, avoidance of harm. Yeah, exactly. Removing personal identifiers if the consent is not in place and you have promised anonymous data to be shared. That's correct. Consent, anonymization, protection of informants. Yes, that's right. The data are true to what was provided by participant. Yes, that is true. Data security, yes, that's another important thing. Participant confidentiality, having a data sharing statement so that others know how to properly use it. Yes, exactly. If you are planning to share it, then you need to think about it and you need to provide it for the researchers for future use. Exactly. Ensuring data is securely stored and transferred and protecting anonymity, maximize reusability, data quality, fair data. Yes, that's right. Transparency, avoiding harm. Yeah. Anonymous data, but also checking data linkages does not mean, yes, exactly, because even if you have anonymized data, there is a possibility that when you link it and combine it with other information that someone can. That's right. Much for your responses. I must say that very knowledgeable attendees today. So, as you said, ethical issues are most likely to arise around privacy, equality, diversity, um, health and safety, and confidentiality, and yeah, these things. Research ethics govern the standards of conduct for scientific researchers. And it is also important to adhere to ethical principles in order to protect the dignity, rights, and welfare of research participants, as you have mentioned. So, ESRC has set out some key principles for ethical research. For example, researchers should ensure that their research is beneficial to participants, individuals, science, and society, and be realistic about the benefits that it is likely to deliver. And sorry, research should be designed and conducted in a way that respects the rights, interests, values, dignity, and autonomy, if possible, of participants and communities, groups as well. And researchers should inform participants that they have a right to refuse to participate free of consequences and can withdraw from the research for any reason without telling the researcher. And here, the integrity demands that there is a clear fit between what researchers say they will do and how they will conduct their research. And transparency means being clear about the nature of the research involved. And researchers must exercise self-critical responsibility in the planning and conduct of their research. And research ethic committees and research organizations have a responsibility here to guide and support researchers, especially when the research involves difficult ethical decisions. And researchers should also maintain the independence of their research, and where conflicts of interest cannot be avoided, they should be made explicit. And independence of research is founded on academic credentials, professional standards, expertise, and experience, and it should be free from any sort of personal, organizational, and political bias. And considerations of gain should be safeguarded at all times. And they should also provide information about the collection, use, and archiving of the participants' data. That is also an important key principle for ethical research if you are planning to share your data. So, sorry, it is important that researchers do not just consider what can be done with the data, methods, expertise, and technology available to them. It is equally important that researchers consider what should be done. So, NSDEC, National Statisticians Data Ethics Advisory Committee, they provide a framework to help all researchers to think about the ethics of their research at an early stage and give them confidence that their plans address those ethical principles and practices. So they have designed a very useful ethic self-assessment tool to review the ethics of the project to be undertaken. And this tool enables to identify and mitigate any ethical issues. I have added a link here. You can check that later on. So the tool is based on 6 main principles. You are asked to assess your project against 22 items. These principles are public good, confidentiality, data security, methods and quality, legal compliance, public view and engagement, and transparency. And there are 22 items that are grouped against these 6 ethical principles on a scale, but it is beyond the scope of this session to go into further details of this tool, but that is quite useful. So please go and have a look into it later on. Then there is another useful resource, which is called Ethics Framework by the UK government. This framework provides guidance on the appropriate and responsible data use in government and the wider public sector. It helps to understand ethical considerations and address these within the projects. And I'll show you a guide available on their website, and I have added a link on the slide. I'll just share it. So that is also a quite useful resource. So this is the guide by the government on their website. And you can see there the basic information such as what is it for, how to use it, the structure and who is it for. And then the framework consists of overarching principles and specific actions that covers the entire process of a project. And each section includes questions that will guide you through ethical considerations for your project. I found it very useful, but it is again beyond the scope of this workshop to go into details, but you can always have a look into this. So you can see here that these, for example, these are the overarching principles: transparency, accountability, fairness, and then there are specific actions. For example, for the transparency, they have just described what it is. Then there is a scale you're asked to score, and then accountability, and then again scoring fairness. So that then self-assessment table for the 5 specific actions. So that's quite useful, I would say. So please have a look into it when you have time. So some of the best practices are that ethical obligations should be considered throughout the research life cycle, from planning and research design stage to the data collection stage, all the way up to the future uses, including publications, archiving, sharing, and linking of data. And it is essential to have a knowledge about the standards and requirements of the relevant research organizations as well. So always comply with the relevant laws, avoid social and personal harm, and you can always check with data centers or archives such as us, as we facilitate ethical and legal reuse of research data and protection of participants and safeguarding of personal data. And you can always seek guidance from us. I have added an email address on the last slide. Feel free to write to us if you need any sort of guidance. And most importantly, consent should be in place for the future uses of the data. And bear in mind that this consent is different to the consent that you seek for participation in research. This is the consent or informing the participants what you are going to do with their data. I'll come to this later on. So section 2 is all about legal frameworks that govern research data. In the context of data sharing, it would be easier to talk you through about the legal frameworks governing research data if I take a broader classification of research data by Health Research Authority. So this is applicable to all the contexts, not only to the health research, but to all the contexts. But it is easier to talk you through if I follow this classification. So, according to the Health Research Authority, data or information is broadly classified into 3 main categories. Information that relates to identified or identifiable individuals, information that no longer relates to identified or identifiable individuals, which sometimes referred to as anonymous data, also known as effectively anonymized data. And then there is synthetic data, which is a new trend. I'll go through each of these briefly and the legal frameworks governing these. So the first type is the information that relates to identified or identifiable individuals. But before that, just a quick introduction to the personal information or data. You can identify an individual through personal information about that person. And people can be identified directly or indirectly, as one of you have mentioned, indicated by linking on the Mentimeter that someone can be identified by linking data. So examples of direct identifiers are name, address, postcode, telephone number, voice, picture, and some of the examples of indirect identifiers are occupation, geography, unique or exceptional values in the data, which when combined can identify a person. So personal data also includes special category data that needs more protection because it is sensitive. And personal data also includes special category data that needs uh, more protection. And UK GDPR defines special category data as personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, or even trade union membership, genetic data, biometric data, and data concerning health and sexual orientation as well. So most health research uses special categories of personal data or biometric data or genetic data and so on. So if personal information about people is collected or used in research, then data protection regulation applies. There are two main legal frameworks governing the use of uh, data that relates to identified or identifiable individuals, which is the common law or duty of confidentiality and data protection regulation. In the UK, there is a duty of confidentiality that is based in common law and that occurs where confidential information comes to the knowledge of a person in circumstances where it would be unfair if it were then to be disclosed to others. But there are some exceptions when you can disclose information. For example, if participant consents to onward sharing of their personal data, then sharing does not breach any duty of confidentiality. And under this common law, you will need to obtain an explicit consent if confidential information is used for a research project. And this is very clear and specific statement of consent. And it can be given in writing, verbally, or through another form of communication, such as sign language. And sometimes public interest can also override duty of confidentiality. And occasionally, there are circumstances when you may need to give up data, such as over a court order. So the best practice is to avoid very specific promises in consent form. I will go through these specific promises. I have added two questions in the Mentimeter for now, so that it is useful for those who cannot make it to the consent workshop next week. So you will know about what I'm talking here. So it is best to avoid very specific promises in consent form. So as researchers, you must adhere to data protection requirements when managing or sharing personal data. So if personal information about people is collected or used in research, then the data protection regulation applies, as I mentioned earlier. And data protection legislations that are most widely applicable to the research are Data Protection Act, EU GDPR, and which is now called the UK GDPR. So I think currently UK GDPR and EU GDPR both are aligned and they place the same legal obligations on researchers, but maybe they may diverge as UK has left the EU. So there may be some changes. It will therefore be important for researchers to ensure that they gain local support from their university data protection officer when their research projects span across the EU. So basically, if the researcher based in the UK collects personal data about people anywhere in the world, or a researcher outside the UK collect personal data on UK citizens, sorry, then Data Protection Act and UK GDPR applies. However, if the researchers are undertaking research projects which span across the EU, then the EU GDPR will also need to be considered and adhered to. So this is the basic principle that you need to keep in mind if your research span across EU or outside the UK. So the UK GDPR specifies the rights a data subject has when when their personal data are processed. Participants have the right to be informed, as some of you have mentioned on the Mentimeter, about the collection and use of their personal data. They also have a right to access the information you hold, and they can request any change in the information. They can ask for the erasure object or ask to restrict processing. I'm sorry. They can also object in terms of data portability or transfers and any sort of decision making. Which of these rights will be relevant to processing personal data for your research project will depend on the nature of the project and the chosen processing ground and in which country the research is taking place. So it all depends on the specific context. Everyone responsible for using personal data has to follow strict rules called data protection principles. They must make sure that the information is used fairly, lawfully, and transparently. They should always, the information that is being collected should always be used for specified explicit purposes, and it should be used in a way that is adequate, relevant, and limited to only what is necessary. And it should be accurate and, where necessary, kept up to date and not kept longer than is necessary. Most of all, it should be handled in a way that ensures appropriate security, including protection against unlawful or unauthorized processing, access, loss, destruction, or damage. So, and it should be kept confidential and integrity should be maintained at all times. Under the UK GDPR, there are 6 possible grounds for processing personal data, and one of these must be present. These are consent, public interest, legitimate interest, protection of vital interests, legal obligation, or performance of a contract. But in the context of research, the first 3, consent, public task, or legitimate interests, are the most applicable grounds for the processing of personal data. Just to give myself a break, there is one quick question on the Mentimeter. If you can just join Mentimeter, please. So this is the code and the QR code as well. So which legal basis have you used or intend to use for your future research project if you have processed personal data? Or you could also mention if you haven't used any legal basis or you haven't processed any personal data, what do you think could be the most commonly used legal base in the UK to process personal data, in your view? I have mentioned 6: consent, public task, legitimate interest, performance of a contract, and then there were 2 others. So diversity checking, Article 6, consent, public task. That's great. Equality Act 2010. That's a great. Diversity checking. I'm not familiar with diversity checking, but it looks interesting that other than the UK GDPR, lawful bases, 6 lawful bases. There are some other as well that are being used in research. So that's quite interesting to know. So freedom of information, yeah, that's another one. So majority, I think, of you have used public task and consent and some of criminal offenses as well. Corruption, that's interesting. I'm not familiar whether corruption is the legal base. I'm just familiar with the 6 lawful bases under the UK GDPR. So that's interesting to know. Employment Act, security of information, assent, ec- um, in loco parentis consent. Informed consent, and somebody has used legitimate interest as well. Thank you very much. So, so someone has written Computer Misuse Act. That's interesting to know. So far we have got 36 responses, and I think main ones are most of you have used the consent and public task. So thank you very much. Let's get back. So, in the UK, sorry, Information Commissioner's Office, ICO, advised that for almost all research conducted in the UK, organizations should rely on either public task for all public bodies, such as universities, NHS, and research councils, or legitimate interest for non-public bodies, such as charities or commercial companies. However, those holding and using health information, which is a special category of personal data, will also require a further condition in addition to the public task. And in academia, this is usually, this further condition is called to support scientific and historical research. And in addition, you may also need to complete a data protection impact assessment, DPIA, for any type of processing, which is likely to be very high risk. So you must therefore be aware of the risk of processing the special category data. So this is a general advice from ICO, but I've seen that some of you have used different ones. So maybe uh, there must be a reason for using those. So a general advice by the ICO in the UK is this, that use public interest for all the public bodies and legitimate interest for all non-public bodies, and additional condition for a special category data. So there is a misconception that data protection laws such as GDPR prohibits data sharing. However, it does not prevent data sharing as long as you approach it in a sensible and proportionate way. In fact, it is useful for research. It legalizes much of the current good practice in research, placing people at the center. And it also offers enhanced rights to individuals whose data is being processed. And in the context of research, GDPR has the potential to further benefit research and archiving, helping to improve trust and confidence between the public and the universities, and between researchers and their participants. And it also allows transparency, and as clear information has been communicated there, it also emphasizes on clear documentation, and personal information is always processed using a ground that is enshrined in law, and then if the research data is being archived, the reuse of their data is always allowed with some safeguards. So it always help. So this was all about the data that can be identified or identifiable. If you remember, I have mentioned there is a second type of data in the earlier slides that no longer relates to identified or identifiable individuals. And this is the data that has been anonymized or pseudonymized. So personal data that has undergone effective anonymization is not regarded as personal data. So therefore, it is not subject to the UK GDPR. That's important to remember. This is because the data has been modified and transferred or otherwise made available to another organization such that it no longer relates to an identified or identifiable individual. And there are several anonymization techniques that can be used. For example, aggregating, suppression, rounding, reduction in detail, addition of noise, and so on. But it is beyond the scope of today's session to talk through these. And as I mentioned, you can just uh, check our YouTube channel or our events page, where my colleague who has the expertise in anonymization and qualitative data, you find useful information. And then I have added some useful links on the bottom of the slide as well for you to have a look. And data that is treated in this way is no longer considered confidential and, generally speaking, does not fall within data protection laws. So it is important to note that even data is anonymized, it may still be possible to find ways of identifying your individual personal information um, when combined with some other pieces of information. However, it would likely require special circumstances or effort, and this effort may involve using other sources of information to narrow down the number of individuals that the data may be referring to, and it all depends on the context and resources um, to identify someone from the anonymized data. But overall, if it is effectively anonymized, UK GDPR does not apply. That's the main takeaway. On the other hand, pseudonymization is a security enhancing process that replaces or removes information in a data set that directly identifies an individual. And it is typically applied before information is shared with a third party. For example, it could involve replacing an NHS number, a name, or an address with a unique number or code, which is usually called a pseudonym, with the effect that identifying an individual directly from data is not possible by the recipient without additional information. For example, the key that would enable matching the pseudonym to direct identifiers in the data set, or means to re-identify the data. So personal data that has undergone pseudonymization but could still be attributed to an identifiable individual by the use of the data alone or in combination with other data likely to be available is legally presumed to remain personal data under UK GDPR, because the key is existing there, which can be used to identify. So that's the difference between effective anonymization and pseudonymization. Effective anonymization is not subject to the UK GDPR, while pseudonymization is subject to the UK GDPR. So the third type I mentioned earlier is the synthetic data, which is a new trend. Not very new, I would say. Synthetic data is information that is artificially created rather than generated by real world events, and it can simulate synthetic populations that resemble the characteristics as well as diversity of actual people. And it can also be generated to be statistically consistent with a real data set, which it may then replace or augment. So As synthetic data is neither personal data nor confidential patient information, it is not subject to data protection legislation or the common law of confidentiality. So far, this is the case, but we do need more and more research or work on the ethical and legal guidelines related to synthetic data. It's not clear yet, but so far it is considered that data protection legislation does not apply because it is sensitive. It is synthetic data. So this section focuses on the role of consent in research. I'm sure you all are familiar with what informed consent is. However, when it comes to data sharing, then consent is used for two purposes: to fulfill ethical obligation and to be legally compliant. We are all familiar with the consent that is used for research participation, and it is considered as one of the founding principles of research ethics, where it is sought before participation in any research activity, and from it is obtained from all participants. And it usually involves providing information regarding study purpose, risk, benefits, voluntary participation as well. But as stated earlier, consent can be used as one of the legal bases of processing. If you remember the six lawful bases of processing personal data, consent was one of them under the UK GDPR. So, if a researcher collects, manages, and shares personal data, then consent of the data subject can be used as a legal base to process this personal information. But if you remember, I mentioned earlier that in the UK, it is rarely used as a legal basis in research context. And we are advised in academia to use public task instead. So, though not mandatory under the UK GDPR, but you need to obtain an explicit consent under common law or duty of confidentiality when you have to disclose or share confidential information for research purpose, um, or for clinical trials, especially in health research. It is mandatory. So, therefore, consent plays a vital role to be legally compliant, specifically when it comes to being transparent, fair, and maintaining confidentiality. And even if the consent is not required legally in the UK, but if you plan to share your data, then as an ethical obligation, you do need consent from the research participants, informing them about the future uses that you are planning to deposit this data at so and so place and what would be the uses of this data. Ethically speaking, you do need to obtain consent from the participants. So, consent can be gained in written or oral form, and the format of the consent depends on the kind of research. It is important that whatever format is used, written or verbal, it should be documented. You should document how it has been gained, what information has been provided to the participants, and what they have agreed to. Especially if you are processing personal data, this is mandatory. And consent form plays a vital role in data sharing. And it is very important that you design the consent form keeping in mind these three important sections in the form. If you are planning to share your data, the first section should be about taking part in the study. That includes some basics, such as participants have read and understood information about the project. They have been given the opportunity to ask, and they understand that they can withdraw at any time without giving reasons and without any penalty. And the second section is about how the information that is being collected will be used. So you need to put all the information in that second section for that relevant study. For example, how the data will be stored, for how long, how the confidentiality will be maintained. And the final section should be around providing information about future uses of the data, such as publication, archiving, and so on. This final section in the consent form is really important if you are to share the data for future reuse by other researchers. And I'll go through these sections in more detail in the consent workshop I'm running next Tuesday. But in the context of data sharing, this third section is really, really important, because most of the time we come across the consent forms that have been used by researchers when they deposit data with us. They do have some statements like the data will be destroyed after, for example, 5 years. So only the research team has access to the data. And so such statements, they preclude data sharing. And the only option for them is to go back and obtain retrospective consent, which is not always an easy option. So I'll go through these next Tuesday in more detail. So when you start a research project that involves collecting information from people, for example, through a survey or through interview or focus group or video recording, then those questions can help you to comply with data protection legislation in practice. The first consideration should be whether the project needs to collect information that would be defined as personal data. If not, then do not collect it. If the research does not collect personal data, then data protection legislation will not apply. We usually, in the consent forms, we don't need the personal information, but even then they are designed, we use just the standard forms in our universities. We ask for names, email addresses, date of birth, even if we don't consider that we don't need it. So if you do not collect this sort of information, then data protection legislation will not apply. But if personal data is being collected, the researchers need to identify who will be the data controller for the collection, storage, and handling of the data. This is unlikely to be the researcher themselves, and most probably will be the researchers, university or institute where they are based. And if the research involves collaborations of different partners, it will be important to identify whether there will be joint controllers of the data or data processors. It will be crucial to ensure data sharing agreements should be in place, and where necessary, a processor controller agreement as well. The data controller, I should explain that as well. The data controller is the person or business who determine the purpose for which and the way in which personal data is processed. By contrast, a data processor is anyone who processes personal data on behalf of the data controller. For example, if you deposit data with us, you are the controller because you decide the purpose of that data. And we are the processor because we process that data on your behalf. So you are the controller and we are the processor. And an assessment will need to be made about the most appropriate processing ground as well to use for each research project. You need to consider that as well. There are three grounds, as I mentioned earlier, that are most applicable for research: consent, public task, or legitimate interest. If you are using consent as the processing ground, it is crucial that this is distinguished from consent for other ethical and legal purposes, and that participants can withdraw their consents for processing personal data. So just keep in mind that it should be different than asking for participation in research if you are using consent as a legal ground. If public task is used as the processing ground, then you must ensure that your university or institute is classified as a public authority and that the research will be in the public interest. And if you are using legitimate interest as a ground, then a legitimate interest assessment should be undertaken. This will need to identify the legitimate interest being pursued, and it should demonstrate that personal data processing is necessary to achieve this. So The information that needs communicated will be influenced by which processing ground is chosen. Broadly, participants should be informed about how any personal data collected about them will be used, stored, and processed and transferred, and who the data controller is, as I mentioned earlier, the legal ground and the purpose of processing, and any recipients of the personal data, the period of retention, and their rights as well. All of these needs to be communicated to the participants. So despite all the information I have gone through, bear in mind that much research data, even sensitive data, can be shared ethically and legally if researchers employ certain strategies. For example, offering protection of identities through anonymization, de-identification, or using processing ground for personal data, or regulating access where needed. So you can share personal data, even sensitive data, by using these strategies. I have mentioned regulating access. So by regulating access facilities, um, it means that you can regulate access, which facilitates data sharing, especially when it is not possible to anonymize data or to obtain consent for data sharing. In that case, you can restrict user access. For example, here at UK Data Service, we facilitate 3 levels of access for data: open access for data that contain no personal information, safeguarded access for data that contain no personal information, but the data owner considers a risk of disclosure resulting from linkage to other data. And it is available under end user license, and users need to register to access data. And users also need to agree to certain conditions, such as not to disclose any identifying information if found. And the third one is controlled access, which is for the data that may be disclosive. And data are available to users who have been trained and accredited, and their data usage has been approved by the relevant data access committees. And access to this data is through a virtual or physical secure environment. So if you could please go to, there is an activity, I think there is a quiz on the Mentimeter, if you could just please. Yeah, using the same code and same QR code. So it's a quick quiz. What do you think? Effectively anonymized data is not subject to the UK GDPR. As a matter of principle, that's true. Effectively anonymized data. Effectively anonymized does mean that you cannot identify a person. So just based on this statement, that's true. It is not subject to the UK GDPR. But if it is not effectively anonymized and there is a risk of disclosure, then yes, it could be if you link it or combine with some other pieces of information. And what do you think? If the researcher based in the UK collects data from the EU, which of the following applies? Yeah, that's right. Both EU GDPR and UK GDPR applies. Thank you. And what do you think? Informing participants about the future uses of data is an ethical obligation, a legal obligation, or it depends? Yeah, you basically in the UK or anywhere, it should be considered as an ethical obligation, but it could be a legal obligation as well. And it depends on the specific context and what you are promising to the participants. And so there isn't any right or wrong answer here. It could depend on the context you are working on. It could be a legal obligation or it could be an ethical obligation as well. So thank you. Yeah, so that's what I was mentioning earlier. In the consent form, if there is a statement, any information I give will be used for research only and will not be used for any other purpose. Is this appropriate to use in the consent form, especially if you are planning to deposit that data in a repository or in an archive for future use? Yeah, it could be true if you are not planning to share it for future use. It is false if you are planning to share it uh, for future use. If you use such statement in the consent form, then it is not possible to deposit that data for future use. And as I mentioned, the only way is to get a retrospective consent from the participants because they have been promised that the information that is being collected is used for this research only and will not be used for any other purpose. So there is a comment that it just disappeared, the comment. As I quickly read the comment that it is limiting for the researcher. Yes, it is. So it is advisable not to use such statements in the consent form. If you remember one slide where I mentioned that avoid using specific promises. So that is all about that. Then there is another statement that we come across um, quite frequently when someone deposit data with us, that I understand that only the research team will have access to the data I will provide appropriate. So again, most of you think that it's not appropriate. Some of you are not sure. So again, I think someone has said that it is appropriate. So yes, there is no right or wrong answer. It always depends on the specific context you are working in. So if you are not planning to share the data for future use, then that should be fine. You are informing the participants that um, uh, no one has access to the data other than the research team. And then there is again a comment here, which quickly disappeared, that most research funders, they do require data sharing. Yes, it is becoming mandatory these days. Most of the funders, as well as the journals, do require you to publish your data for future use. So such statements should be avoided. Because this is quite a recent trend that funders and the journals they do ask you to deposit your data for future use. So you should avoid that if you are planning to share their data. Mhm. And again, this is the same. Such statements should be avoided if you wanted to share your data. Yeah, as that's quite interesting to read that it would be problematic from the participant perspective as well. Yeah, especially if it is a focus group or interviews and participants have spent a lot of time giving their thoughts and views and they are reading that everything will be destroyed after 5 years, 10 years, then what's the point? So yeah, that is interesting to know that there lies a participant perspective as well to such statements. Thank you very much. Yeah, so that is all for now. Thank you for the responses. So this is the final section, which is the key considerations in secondary data use. So Uh, Two most relevant types of rights applicable to the secondary data sources are copyrights and database rights. I'll talk you through to the copyright, which is most important due to the time constraint, and I have added a link at the bottom for other rights for you to have a look. So copyright or IP right are assigned automatically to the creator or the researcher who owns the data. When data are shared or archived, the original owner retains the right. And data archive cannot archive data unless all right holders are identified and give permission for their data to be shared. You can find more information on rights in research data and different scenarios to get more understanding on this topic. And I had a workshop last week on copyright in secondary data use. You can find the recording of that workshop, which has more in-depth detail on this on our YouTube channel. So copyright applies as soon as the data is created. You are the copyright owner of the data that you share for the future use by other researchers. And in the context of primary data, if you plan to share it for future use, you need to consider how you want your data to be reused by other researchers or students. And you can specify this by licensing the data to match the intended uses. Um, Various types of licenses for sharing data have been developed by the data archives. And I've shown you that we have these access levels, but in my copyright workshop, I have gone through the Creative Commons licenses and the bespoke licenses and end user license that we use. So you can find more detailed information on the licenses in that workshop on our YouTube channel. So in the UK, copyright arises automatically once the work is created, and to enjoy copyright protection, the work must be original, not copied from someone else. There is no copyright in ideas or facts, only in the way these ideas are expressed, such as diagrams or tables. So as researchers, when you need to obtain copyright clearance, so for this, bear in mind that you do not need copyright clearance if you incorporate the factual data in your own words in a structure owned by yourself. You may not need any permission. If you are making a copy and utilizing that copy for your own research, as long as it is not made available to others or citing from the research data. However, you do need copyright clearance if you are going to include this data in a publication or plan to share the data with other people. So just keep that in mind. You can use any source for your own personal use, but if you are sharing it for future use, then you do need copyright clearance. So I would like you to read this scenario here and then go to the menti.com and use the same code again. I have added both of these questions there for you to answer. So here our researcher studies how health issues around obesity are reported in the media in the last 10 years. Freely available newspaper websites and library sources are used to obtain articles on this topic, and data includes articles and excerpts. So the two questions are, can the researcher use such public data without breaching copyright? Can the data be archived and shared with other researchers? So I'll go to the Menti. So that's the same code, same QR code. So this is the first question. Can a researcher use public data without breaching copyright? What do you think? Yes, depends on the terms on which data was made publicly available. If properly referenced, yes. Yes, so most of you have said yes. as long as it is properly credited. Yes, if it is in the public domain. I can use it but cannot publish it as such. Depends on licensing, properly reference. Yes, if the newspaper and sources allow. Yes, so the question is, can a researcher use public data without breaching copyright? So as some of you have mentioned that yes, for their personal use, as long as properly referenced, you can use it for your personal use. But when it comes to sharing it at other places, then you must need to check the licenses attached to it or copyright permissions that you need to obtain. So that is, I have already answered, and some of you have already answered that as already answered that. Can the data be archived and shared with other researchers for future use? So that was answered already. So need to check permissions only if permitted. That's absolutely right. Depends on licensing and permissions. Yes, you do need to check the license and terms and conditions associated with the information. Information that is available in the public domain, freely available in the public domain, does not mean that you can do whatever you like with that information. If it is for your personal use, then that is fine. But if you plan to share it or archive it somewhere, then you do need to check the terms and conditions, licensing, permissions. That is right. Thank you very much. So, if you are using secondary sources, then best practice is to assess who the copyright holder of the data set is. Are you allowed to use them and in what way? Are you allowed to archive and publish them in a data repository? And as I mentioned, most of the time we encounter problems when researchers are allowed to use data as the data is under open license or they register to use it or pay for it. What they do not realize is that it is accessible to them for their use and they need permission from the data owner for sharing it or archiving it. So then there is always a problem. They need to get back to them and ask the permission. So if you if it is if it does need permission, then you do need to get back to them and obtain a copyright clearance. And if somebody does not allow it, then you need to remove the copyright material before you share it for future use. So to be legally compliant, always investigate early which laws applies to your data, including cross-country collaborative working as well. Do not collect or keep personal or sensitive data if it is not essential to your research. Plan early on and seek advice from your research office and ensure that you check participants know how this data will be used. And remember, not all research data are personal data. For example, anonymized data is not personal data. So I have added some resources here for you to have a look at it later, which you can find useful. The resources include link to our website, link to our model consent form, some examples of consent forms, examples of information sheet and rights and regulating access. And then there is a link to the book, which is a guide to research data management. So these are the links for you to register for our for the UK data service, and then again this QR code for our training and events if you would like to have a look at it and register for upcoming events. So this is the email address, data sharing. It's the shared mailbox. Either myself or my colleagues will be available to answer any project related specific queries, or you could directly email me as well if you have any queries.